Should publishers send free copies of their print-on-demand reprints of public domain material to the Library of Congress? Under the first Copyright Act in 1790, copyright registration was required to secure federal copyright protection, including a requirement of deposit of 2 copies to allow courts to compare an alleged infringing work to the actual work registered for copyright. This law was modeled on the Statute of Anne from 1709, which contained a provision requiring a copy of a registered book for the Royal Library. Subsequent copyright laws have made registration optional. Copyright law is now being used to force publishers to send free copies of their reprints of public domain material to the Library of Congress, which has controlled all copyright activity, including deposit, since 1870. One such publisher is Valancourt Books. It is a small independent press located in Richmond, Virginia, which specializes in rare, neglected, and out-of-print fiction. Rather than producing a run of thousands of books and storing the inventory to fulfill future orders, Valancourt's books are printed one at a time by a digital printing vendor. Many of the works that Valancourt publishes are older works in the public domain. The editorial enhancements that Valancourt adds to the works, such as scholarly introductions and footnotes, are subject to copyright protection. But Valancourt has chosen not to register this new matter with the U.S. Copyright Office. In 2018, Valancourt Books was served with a notice by the U.S. Copyright Office, which is located in the Library of Congress, that they needed to remit 2 copies of the best edition of 341 books, essentially their entire catalog. If they failed to do so, they would be liable for damages of a fine up to $250 per work, so $85,250, and the total retail price of the copies demanded. Valancourt pointed out in their response that the works demanded were reprints of public domain materials, and provided cataloging information to show that these works were already at the Library of Congress in their original editions. But the Copyright Office persisted, and Valancourt brought suit, arguing that this request was a violation of a takings clause of the Constitution. Printing almost 700 copies of books would cost them $2,500, and there had been no offer to compensate them for their property. The Copyright Office argues that anyone who publishes anything is the copyright owner, who is required to deposit within 3 months, regardless of whether they make any effort to register the copyright. In a print-on-demand context, this means that the Library of Congress can demand any print-on-demand book, regardless of whether they sought to register the copyright. The publishing market has fundamentally changed. The idea of digital production and print-on-demand was on no one's mind when mandatory deposit began, and asking that copies of a print run be sent to the Library of Congress was a fairly minimal burden. The application of mandatory deposit rules to print-on-demand publishers risks chilling innovation and the availability of works in an era where the marginal cost of a best available copy of a work costs $20 to $30, compared to a print run where the marginal cost of additional copies is fairly minimal. Should the copyright deposit rule be amended, or does it still serve a purpose? Should there be the same sort of exemption for small print-on-demand publishers? Should reprints fall under the same regulations as original works?